This is the legal panel. There's a lot going on in the world of law today, even more going on in the world of politics. So I want to let my panelists introduce themselves. Veronica, let's start with you.
I'm Veronica McGregor. I'm the Chief Legal Officer at Exodus.
Hi, everybody. Andrew Hinkes. I'm a partner at Winston & Strawn.
Good afternoon, everyone. My name is Chris Humphreys. I'm the Managing Director of Stewart's Attorneys in the Cayman Islands.
Good afternoon, Brian Klein. I'm at Waymaker and I'm a litigator.
All right. So, Veronica, tell us, what are you looking forward to in the U.S.? Give us a top 3 things that are coming down the pipe. Obviously, the U.S. has got all the spotlight right now, and I think rightfully so.
Like a top 3, I don't know. I know that as we speak, I believe the SEC is holding a closed-door meeting to discuss what they're going to do with all these open cases and try to settle them or drop the enforcement actions. So we can all be pretty happy about that if it happens, which is supposed to be happening right now. I think we can look forward to some rollbacks of some of the more troubling regulation and rules like SAB 121. And we can look forward to a clearer path for, token offerings. We can look forward to a clearer path, and hopefully, we're promised clearer regulation rather than, regulation by enforcement as we've been dealing with since, well, kind of the inception of crypto. And yeah, that's some of the broad strokes.
All right, so we have a litigator on the panel, in fact, Brian. Is the SEC going to drop all the cases or what?
Well, I think everyone hopes so, and I think there is a path for that to happen. I think people might have seen there was an announcement earlier this week where the SEC acknowledged, at least partially, that they were using enforcement to bring in regulation, and that they were not being judicious in how they were using their resources. So I think the SEC is going to dial back significantly what they're doing. It's just a matter of when, not if.
Is there precedent for the SEC just dropping cases that are ongoing when the administration changes over, like it just did?
That's unusual, but I think it speaks to how Gary Gensler conducted himself, not to necessarily this administration, in the sense that he got way out in front of things, and brought a lot of cases he shouldn't have brought. And so it would make sense when you get a new administration and a new set of commissioners and a new chair that they would want to change course.
Yeah, well, speaking of changing course, did anybody see the announcement of the crypto task force? Raise your hand, the new crypto task force? Yeah, so there was a crypto task force in the SEC. Now there's a new one, presumably, certainly with new leadership and presumably with different goals in mind. Who here on the panel saw that announcement? Yeah? Drew, what do you think?
Given the expectation that there is a really significant change of focus and presumptively a change in policy, this is a very encouraging development. The real question is, what is this task force going to do? What is its charge? Who's going to be on it, and what are they going to be ultimately doing? My understanding is that there will be members that will come from government, from industry, from academia, from stakeholders, and that they're going to discuss this new path, this new policy that seems to be coming top down from the new Trump administration as to finding workable solutions for the industry. Brian spoke to the retroactive question of what do we do with what came before. My understanding is that the task force job is going to be to chart the path of where are we going.
Makes sense. Well, at least we know a little bit about where we're going because we know where we just came from on Friday, which is the first presidential meme coin. Right? Anybody buy any Trump? Okay, we got some cheers. For the video, we got some cheers in the audience.
Melania? Did anyone buy Melania?
Oh, did anybody buy Melania? Got some Melania believers here as well. Do you think that's some indication of administrative policy? What is the effect of Trump coin? Like, practically speaking, when your clients come to you and they say, hey, the president just launched a meme coin. Wait, his wife just launched a meme. The first lady launched a meme coin. God knows what's going to be next. what does that mean? What does that mean for the industry, for the ecosystem, that the President of the United States has launched a meme coin against a backdrop of incredibly aggressive regulatory enforcement actions?
I mean, I got the obvious question from lots of clients I'm defending in various things. How can they be going after me, right? This must mean should be in the clear now. And I think that's a clear indication, at least of where his head is and what they're thinking. And I think it's a very positive sign for the industry, setting aside how people view the meme coin itself.
Two quick points on that. We use terrible language in our industry. We use words and we don't really have a consensus understanding of what they mean. People talk about a meme coin as if it's a thing that captures the zeitgeist of a community or facilitates people getting together and collaborating on things, but there isn't like a canonical legal definition of a meme coin. Meme coins, or what are marketed as meme coins, sometimes end up looking more like securities than they should, at least under the prior understanding of security. What's kind of interesting about the Trump and the Melania coins is that there was actually a fair amount of disclosure associated with those tokens. And if you look at the web pages and the announcements, arguably there's better disclosure around those tokens than in 80 to 85% of the tokens that have been launched in the market. So, even under a very aggressive view of the securities laws, like the prior Gensler regime, I think there are some really interesting questions as to how those tokens would be considered. And it could be, hat tip to the team for doing a thoughtful job in what they did. But that sort of, if you pull that back a little bit, it sort of begs the question of why are we in a world where meme coins are the cycle anyway? And I think there's a good argument that the prior positions of the SEC making it difficult to bring the kinds of instruments and the types of investment opportunities that people normally would want left us in a world where the only thing that we can do is the meme coin bake sale model of, here's the thing, if you want it, you can buy it.
Okay.
I would expect you're going to get like tons. I'm no longer private practice, but if I were, I'm pretty sure I would have clients lining up to launch their, pickleball coin or whatever it is. So,
Wow.
So did I just give you an idea, Marco? The pickleball coin.
Okay, let's
Coming
play
soon
this
for Marco.
through. Now, we're not going to talk about pickleball coin, but I do want to play this through. Your counsel to the president in this fact pattern. The president comes to you and says, my son tells me I should sell a meme coin. What are the considerations? Should I do disclosures? Should I not do disclosures? Should I sell it outside of the United States, even though I'm the president-elect? What do you tell him?
Get a big retainer.
Yeah, exactly. Get a big retainer. That's true. That's true. But also, disclose, and put restrictions on trading.
So what were some
for
of the
insiders.
disclosures then around the Trump coin?
They disclosed the amounts of holdings of various entities. They disclosed them by name. They talked about emissions and unlock schedules. And my understanding, it was launched in a way that was somewhat transparent. None of this relates to the things that a lot of other token issuers got in trouble for. But if we go back to the original intent of the securities laws, which is, we want to have organized markets, we want to facilitate capital formation, we want to protect consumers. The way we typically protected consumers was not by taking something that they're profitable on and all of a sudden deciding in an enforcement action that it's a security. We make disclosures in order to give them understanding of what they're investing in, and we sort of don't judge the merits of things. This is a little bit of a throwback to the days when you could make disclosures and then people could make a decision.
Right, without consideration as to whether they're accredited or not accredited or sophisticated in any way. But what about the restrictions on trading for insiders?
I don't know anything about that.
Yeah, right. Wasn't that part? But isn't that one of the reasons why the Trump and Melania coins were less, people were less critical of them?
Well, they do have some pretty considerable reserves of the overall float kept for the company and for the issuer, which they did catch some critiques for. But if we assume that if there is disclosure and that there's an agreement that they're not going to sell, that those agreements would be abided by, and that would be sort of how we would expect in the real world the process to work.
And I will say, in defending clients, whether in private lawsuits that are brought or government actions, disclosure is like one of the most helpful things to pointing out, hey, there wasn't a problem here. Look, they disclosed all the key facts. They told everybody, okay, they're not happy. Not everything turns out perfect in life. That's how life works. So I think disclosures, and I understand they were very robust and well done here, that's just such a helpful point no matter where you end up, because it just tells the world you're trying to do the right thing, trying to put people on notice.
So, okay, Chris, from the Caymans, are you guys just watching with a box of popcorn here? I mean, what is this? Is this like a circus sideshow to you, or do you think there's actually value here? Maybe not in any particular meme coin, but in this new trend of launching funny ideas with financialization.
Yeah, it's tremendous. So for the last 2 years, we've been setting up funds to invest in this market and tokenized funds. And the token issuing entities, the NFTs, the meme coins, the tokens, all those have been on slightly the back burner. They were very, we set up thousands in 2018, 2019. Last couple of years it's been much more quiet. So absolutely, we're expecting this to pick back up again through the course of this year. It's very exciting.
Do you think there's any difference in launching let's just call it a meme coin, right? We're talking about Trump coin. Is there a meaningful difference in launching a meme coin from the United States today in January in 2025? Is there a difference in launching the meme coin from the United States or from the Caymans?
Well, that depends. So, I mean, the disclosure requirements are pretty high in Cayman. At least, that we would ensure that they are fully disclosed, as would be discussed. It's really there to protect the issuer at the end of the day. So, we don't distinguish between security tokens, utility tokens, or any other kind of token. It's a token, and it requires disclosure. Yeah, we don't have any of those hoops to jump through. So, in that sense, yes, things are simplified. However, as soon as you've got a nexus back to the United States, then it becomes a United States issue as well. So, yes, it's incredibly easy to launch a token issuing entity in the Cayman Islands, and much simpler than it is in the US. But that doesn't mean you don't have to observe the US laws and regulations as well if you've got a nexus to the US. So in some cases, sure, you may be able to avoid the US nexus altogether and just have a very simplified version in Cayman, but it won't always be the case.
And what are you advising, Drew? You're in the United States, you're a US lawyer, got a big practice in crypto. When clients come to you and say, hey, all my friends are doing Cayman's foundations for their token issuers, why don't I just do a Delaware corporation?
So we've never had the clarity that we needed to be able to give really, there's no like one standard that every instrument could be held to. There's no one way to do this. Over time, we've seen different offshore jurisdictions be used. For a while, everything was done through Panama. There are folks that like certain registered jurisdictions like VARA out of the UAE. But I think for the most part, over the last few years, 90-something% of tokens have come from some version of a Cayman or BVI structure. Right now, we're looking at a time of obvious uncertainty, and all the trend lines are suggesting that the developments are going to be positive. For people who have called up and said, Trump just did a meme coin, I want to do that too, can I just create a US entity in YOLO? The answer is, are you the president? And if you are, and you have, based on Trump versus US, full immunity for what you do as the president, then I don't know why you're bothering to call me. And if you're not the president, then you have to start to think about all of the different countervailing implications of this. Let's say that we think that there's risk off in the securities world because of what we see in tea leaves that we're reading with respect to the securities world. That's great. That reduces the risk a little bit. It's not zero. You still have to think about derivatives law. We haven't really heard from the CFTC that they're just going to fold up their tent and go away. And there's still money transmission and money service business risks if you're not a security. And we certainly haven't heard about anybody in the new administration say that they're going to repeal the BSA. I would be in favor of that. I think that the California bankers case needs to be brought again, and maybe this Supreme Court might not dismiss it on standing. It's a somewhat lower risk environment right now, but by no means would I ever tell a client, let's set up your Delaware C Corp in YOLO.
Are those the only two options? Caymans, Delaware?
217 countries out there. You know, are you asking me where we see the most token issuance activity right now?
I mean, it's a question. I guess I should ask you: is it a question of fashionability? It used to be so fashionable to form a Swiss Stiftung, right? And that was the Swiss Foundation was the approach that Vitalik took, and so all the projects took that for a year, right?
So
And
Swiss is great if you have somebody who can be in Switzerland to sign wet ink documents. Otherwise, it gets really impractical. And there are all these other jurisdictions that have said they want to kind of be the place for this. But in many cases, they might have a good law, but nobody outside of that country has ever heard of this law. You can't find lawyers who can effectively negotiate with them because they don't understand the law. Or you have those pieces in place, but you don't have professional services providers that can give you the additional services that you need. So you can't get accountants. You can't find technical folks that are working there. So there's a lot that goes into where you set up a business, and in something that's really complicated, like an offshore structure for the issuance of an instrument, there are really a lot of different factors at play.
I just want to add, that is absolutely true. My former company, Shapeshift, was a Swiss company, and we needed to re-domicile, and because Switzerland was being very, very difficult, and yes, they have very old-fashioned red tape. So if you're considering doing any of this stuff, forming a foundation or whatever, you want to take a look at how much red tape is involved, because it is ridiculous. But then there are other countries that came in and said, oh, like Malta, oh, well, we want to be the next place where everyone, we're a crypto haven, but there were no people there that could do the work, and there were pretty draconian rules about just getting an application in. So it's worth shopping.
U.S., Caymans, Switzerland.
I think I've started to hear about issuances coming out of VARA in the UAE. Obviously, MiCA has come into effect in the EU, which is promising and very interesting. It provides a framework for compliant issuances of certain types of digital assets and frameworks to provide certain services like centralized exchanges. It's new as of January, and it's unclear exactly how well it is going to work, but it's very promising. And a lot of actors in the United States are prioritizing compliance under MiCA because they need it to maintain their presence in the EU market. And the hope is that MiCA is a good success and can become a model for others to potentially learn from.
So we've mostly spoken about one kind of plaintiff, that is to say, one kind of threat to your project. Public plaintiffs, right? The government, the SEC, I think we mentioned CFTC briefly, but that's obviously not the only threat to a project from a legal perspective, and even not the only threat to a project from a litigation perspective. What about private plaintiffs? What about class actions? What about getting sued for securities fraud or just Section 5 violations? Are there private causes of action for that? Can somebody sue you because they bought a token from you for $1, price goes down to 50 cents, and they say, actually, what you did was sell me a security, and I'm not an accredited investor. Plus, you didn't make good on all these promises you made in your white paper because you included a roadmap. Maybe you thought you were being smart about making a disclosure. You were doing the right thing, but you know what? I relied on that, and I don't see you making good on that roadmap. It smells like fraud. Are we seeing any of that?
There's a lot of that. There was a lot the last 4 years. There's going to be a lot of that the next 4 years. The private plaintiffs bar is well-funded, creative, always looking for new cases and looking for markets that are evolving, changing, growing, and have some money, and that's crypto. So I think private litigation, I would expect only to grow in the next 4 years. Different forms of it may grow more than others. Right now there's still a lot of unregistered securities offering cases, but privately being brought in federal courts and state courts around the country. There may be different kinds of cases brought. So I think that market is only going to grow, and I think founders, people running these companies need to be mindful, okay, maybe that's a better environment for the SEC and all these other alphabet soup agencies, but you still got to think about private litigation. And I bet one reason the Trump meme coin, to go back there, they probably had a lot of disclosures, was to also head off that. That's one of their other worries, surely.
Have you expected to see more or less in an industry like ours? More or less private litigation?
More. The more money there is to fight over, the more people will fight over it. That's just a legal truism.
Yeah. Yeah, I mean, we've had to defend a number of private plaintiffs. I mean, particularly there are those that go around and just sue exchanges, right? Whether it's under securities causes of action or duties that we had to our users and that sort of thing. Litigations are public and you can see them. It's been a huge piece of my practice over the years.
And it's one reason people go offshore, too. It's not just because of the SEC. A lot of people want to stay offshore because they view the U.S. legal system as a very expensive morass. It's one I'm in every day, so, but that's the view offshore. When you talk to people, they're like, well, can we avoid the U.S. because I don't want to be sued privately? Chris, you might have some insight into this.
Well, that's interesting. I would ask if you think a Cayman entity, an offshore entity, being an issuer or foundation, would actually prevent and does in fact prevent investors from taking action from the U.S. investors from taking action from the States against a Cayman entity. Do you think in some cases it does, where it just feels a little bit harder to do?
It feels harder. It definitely makes it's a barrier in some sense. It's a cost barrier. It's a thinking through it barrier. But look, if there's a lot of money in a Cayman's entity and people want it, they're going to figure out a way to bring a lawsuit in the U.S. and maybe bring a parallel action in the Caymans or in London or whatever. I mean, lawyers are creative and the plaintiff's bar is very creative.
Wait, Chris, so do we hear you saying it's harder to be sued it's harder for your Cayman foundation to be sued than for your typical Delaware corporation? In the context of a token sale, in the context of a token ecosystem?
In reality, I think the action would commence in the US, and the US lawyers would run it much like any other litigation. In practice, and I guess this was my question, whether my colleague is seeing investors being put off by the prospect of litigation, it's the perception that in instructing another layer of lawyers in Cayman to increasing the costs and having that sort of duplicitous sort of action going at the same time is a cost effect, whether it puts people off from a cost perspective or just from the headache perspective.
Okay. So Brian.
Yes, Marco.
Token sale purchaser comes to you and says, hey, I bought these coins, they were for $1, now they're worth 50 cents. I bought them from a Cayman's foundation, I want to sue. What runs through your head? You think, is it like what Chris is saying? He's thinking, now I got to associate local counsel. I don't really understand Cayman's law. I got better stuff to do. I'm going to send this client on to the next guy.
It's, lawyers on those cases evaluate three things: liability, damages, and collectability. So you're going to look at how easy is it to prove that you've been wronged, right? That's the first one. Damages, how much did you lose or your group of people lose? And lastly, can I get that money? And if I can find ways that are big dollar signs on all of those and collectability, yeah, I'm interested. And, we do plaintiffs work at my firm as well, and we'll spend time trying to figure that out. I mean, if it's a big pot of money and our client's been hurt, yeah, of course we're going to see if we can rope the Caymans in. Maybe a lot of times these foundations have a sub, or their executive lives in the U.S., or there's some tie to the U.S. You will spend some time trying to get them into court in the United States if those other factors are all in play.
Sounds like it's harder to sue somebody. It sounds like it's harder to sue somebody in the Caymans. That's what it sounds like to me. It sounds like, practically speaking, it's a hot mess.
It's like anywhere abroad. You have to think it through. It's no different than if the person's in France or the person's in, it's part of the Western world. So that's better. It's not some country like Russia. You'd be like, well, no, we're going to pass. But So, companies and clients get sued in the Caymans all the time.
For sure. But it sounds like if you had your druthers, you'd be
I'd rather they be down the street.
Delaware defendant over the Caymans defendant every day.
Yeah, that's a lot easier. You hear Delaware corporation, they have headquarters in San Francisco, and their bank accounts in San Francisco, you're like, yes.
You heard it here. You heard it here. Call Chris. Okay, so we've spent a lot of time talking about the securities laws today and liability around token sales. But, you know, those of us who have been around crypto for a long time, which is a lot of the people you see on this stage right now, know that the SEC is only a recent topic of conversation, really the last 5 or, 6, 7 years. Before that, who was it? You guys remember, right? FinCEN. It was FinCEN. It was the United States Treasury. And those laws are not easily changed. You heard Drew talk about some of the risks and the limits of the Bank Secrecy Act, the BSA. Let's bring this full circle. We've got a new administration. We've got a powerful crypto lobby. The audience here is deeply engaged, and they're representative of the rest of the world of crypto users. Is the United States, is the new administration in the United States going to use crypto as a lever to make dramatic changes to the Bank Secrecy Act? Hold on, think about it for a second. Think about it for a second. The Bank Secrecy Act, right, is the law that requires KYC, know your customer, right? This is what stands in the way of financial inclusion most of the time. People need IDs. They need the financial institution needs to do follow-up, enhanced due diligence sometimes. These are things that stand in the way of individuals getting bank accounts, getting access to the financial system. Lots of complaints from the community, from the industry about the Bank Secrecy Act, but at the same time, let's be real, it does catch bad guys every now and then. So, is the administration going to use this new crypto era as a lever to shift the BSA out of place?
I'm not sure they're going to, honestly, they can amend the BSA, or they could clarify some things in a way that eliminate like self-custody wallets. Like there's guidance from 2019 that basically eliminates self-custody wallets from self-hosted wallets, whatever you want to call them, from inclusion as a definition of financial institution. So they could just clarify that and make it more of an actual regulation, or make that less just guidance-y, or they could actually amend the BSA, or they could just not enforce, right? So like they could just choose to not pay attention for another few years.
Let me offer maybe a jazzier take on that. We saw guidance in 2013 from the FinCEN and then in 2019. And at the time, it was probably the best guidance from any regulator because it was deeply engaged with how the technology works, and it covered a lot of ground with respect to how people use digital assets and the technology that they use and their behaviors, and that was great. And the industry really tried to build around all that. But recently, in some of the enforcement actions that were brought, the regulator has said, it's just guidance, we're not bound to it. And that's really, really frustrating for everybody in this room, for the lawyers that want to advise our clients and for the clients that want to figure out how they can design their products to not violate the law. I don't know what is going to happen, but I think that there's a real opportunity to kind of step back and to reconsider the approach. I've heard/seen on social media channels that there are some that really do want to challenge the application of the BSA, and specifically the statute that allows for penalties, which is 18 U.S.C. 1960, to be applied against people who engage in some transactions involving digital assets. I'm personally of the view that the entire BSA apparatus could be radically remade to accomplish the same goals without nearly as much intrusion into privacy. And if anybody ever asked me, I could tell them my thoughts on that, but I'm one guy, one opinion. But I do think that in this opportunity for there to be really drastic change, there is an opportunity to rethink something that its impact isn't just on crypto, its impact is broadly on all of us to the extent that we use any financial institution. It requires the collection of information about us, and in certain cases, the government can get information about you from a third party without a warrant, where in any other case they would need to get it from you with a warrant. So there's really broad constitutional implications that can be addressed here as well.
And I have, I think, one of the cases Drew is referring to. I represent Roman Storm, who's one of the co-founders of helped launch Tornado Cash. And in that case, the prosecutors have said, well, it's just guidance. You don't have to follow that, Your Honor. Let's talk about how we interpret the law. So I think this is coming to a head in a lot of ways, including the case I have. And I think it is a real...
Post too? Explain how corner post might complicate that even further.
Well, I think there's just a lot of things happening right now in terms of our case, what the industry wants, and what's happening in other kinds of cases out there. And I think I'm hopeful by the end of this year we'll have more clarity about this. And I think FinCEN, which is going to have new leadership, I believe hopefully will, and to Drew's point, issue more guidance, because I think they did on some parts I think they did a great job, on other parts I have my quibbles and criticisms, but I think Drew is right. Their guidance in 2013 and 2019, the industry did try to build around. And then the case I have caused everyone to throw up their hands and say, wait a second, what? You can launch something that you don't control and you don't take custody and you're a money transmitter? That's crazy. And I think that's caused a lot of uncertainty in the industry.
Brian, Chris, Drew, Veronica, thank you so much for being up here today. Thanks, everybody.
Thanks, Marco.